relationships in the past, which have caused complete destruction for her. She's lost custody of her children. It's caused drug use.
I'll tell you, in this court, with regards to drug use, honesty is always the best policy. All right. Good luck to you. Court is calling 2023 CR 3442 State versus Robin Huerta Hernandez. Can I have parties announced for the record for the state? Defense.
This is Pauline Portillo for Miss Robin Huerta Hernandez.
And are you Miss Hernandez?
Yes,
All right. And you need to slide over a little bit so that the state will have room. All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes,
Are you the same Robin Huerta Hernandez who was placed on deferred adjudication in 2023 CR 3442 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on August 17, 2023 for a period of 2 years? Is that you?
sir.
All right, state.
Your Honor, we wish to proceed on violation of condition number 4 in Bexar County, Texas. The defendant, Robin Huerta Hernandez, did then and there fail to report to the supervision officer as directed for the months of April, May, June, July, August, and September 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
We waive and abandon the remainders.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? You need to
Yes,
speak.
yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4? All right, so here's the thing. Let me explain this to you. You've entered a plea of true to violation of condition number 4. Maybe you and your attorney have worked out an agreement with the state. I don't have to follow that agreement. The reason why I don't have to follow that agreement is because you don't have a contract with the state or with your attorney. The contract is with the court, and that contract is your conditions of probation. So by pleading true to violation of condition number 4,
Boom. The reality check. The judge makes it crystal clear. Plea deals are just recommendations. At the end of the day, it's the judge who holds all the power. A brutal reminder for anyone thinking the paperwork.
I don't have to follow any agreement that has been reached between you and the state. It's just a recommendation, right? So you're looking up, I could revoke you and sentence you to 2 years. I could send you up to 10 years and I can sentence you up to $10,000 fine. Do you understand? Knowing that, do you still wish to plead true to violation of condition number 4? All right, do you want to step back and talk to her some more?
No, no, no,
Yes.
no, yeah.
Okay. Yes, Your Honor.
Sure. And you're Miss Hernandez? All right, so you had entered a plea of true to violation of condition number 4. The court explained to you what the implications of the plea of true. And I gave you time to confer with your counsel. So do you still wish to plead true to violation of condition number 4? Do you understand by pleading true to that violation, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? And is there a proposed agreement?
Judge, so there's not really an agreement. Each side's asking for something different. As far as the state and what the state is asking for, we are asking that you deny the motion. However, we're asking for you to alter and amend her condition. We'll continue her on deferred, but alter and amend her conditions for a 1-year extension and order her to go to safety due to the struggles that she has had with reporting and failing to submit to her UAs.
All right, defense, what are you requesting?
Judge, we're asking for the extension of the 1 year as well, but instead of SafeP, we're asking for some form of supportive outpatient treatment. Since Ms. Huerta Hernandez was released, she's been doing almost daily NA meetings online. She's been checking in with Ms. Lanier, her pretrial supervision officer, which I have an email from her in Defendant's Exhibit 1 that she's been in full compliance, no violations on her GPS.
Any
I
objection
have
to?
a chance to review it. I have no objection.
All right, I'll review that.
And the MTR alleges drug use in February, but There have been no positive tests since then. I do intend to call Mr. Mike Hernandez, her fiance, and Miss Hernandez herself to explain the non-reporting. I urge the court, if they're between making a decision between SafeP and what I'm asking for, which is a supportive outpatient program, that they send Miss Huerta Hernandez for drug testing. I do believe she's going to come up negative. And I do believe that I'm going to put on some evidence.
So why hasn't she been reporting?
Judge, it seems like around the time that she stopped reporting in March, she was dealing with some homelessness. And she recently connected with her fiance, and she's now living with him, which was not a circumstance back when she stopped reporting. He's been keeping her on track, helping her to get clean, helping her to look for employment. She has been a victim of abusive relationships in the past, which have caused complete destruction for her. She's lost custody of her children. It's caused drug use.
See what's happening? The defense is stacking up mitigating factors: health issues, family support, NA meetings. This is classic advocacy. Humanize the client, show stability, and convince the court she deserves another chance.
It's led to a diagnosis of bipolar disorder and depression. And so at this point, I think she is in the best position with the support of her fiance, with the support of her fiance's mother, who have been waiting here all day for her. And I think she's just right on track, Your Honor, to not relapse again. She's been doing everything she's supposed to do. She also has some medical disorders that I think are going to cause a problem for her if she had to go back into detention. She has a little eye infection, if the court could take notice of. She has a cut eye that I think she needs to get treated pretty soon, and she has asthma that she said was very difficult for her when she was in SATIF. And Your Honor, I think just the circumstances for her right now are going to be optimal for her to succeed and not relapse. She has no criminal history besides this case. So at this point, I'm asking you, add conditions, weekly UAs, random UAs, zero tolerance, can keep her on GPS. She would like to look for work as a housekeeper at this point to help contribute to the household and get some visits back in. She has ordered supervised visits through Guardian House right now with her 16-year-old. So she really just wants to get her life back together and get back on track.
I'm sorry, what did you say about her and the 16-year-old?
She's supervised visits at Guardian House right now. They cost quite a bit of money though, so she will have to work to try to get those visits in. But that's my understanding from what she tells me is going on with that minor child. She does have older children as well. They're adults. They were here at the last setting, but as far as just the minor, she really has to rebuild that back up because her past relationships have really caused havoc in her life.
Okay.
And have led to these behaviors.
And state.
Judge, I am in agreement. This is her first MTR. She doesn't have any additional criminal history other than this. However, she has had some issues reporting, and I just think she needs a more structured environment to really help her if she's really serious about getting clean. She did complete SATIF, but did struggle in aftercare, and then just kind of falls off the grid, absconded from the jurisdiction of the court. And there haven't been any positives because she hasn't submitted to UA. And so that's why I'm asking for what I'm asking for, Your Honor.
And Judge, I meant to tender Defendant's Exhibit 2 also, which is the verification that she's been attending the NA meeting.
Mm-hmm.
Submission and published to the court.
Yes. If you drug tested today, what are the results going to be?
I get it.
All right, you're going to go do a drug test today. Bashan, she's going to go do a drug test with felony drug court. So if you could have her go, and I'm going to send you some information of who to contact, and they're going to want a photo ID. So if someone can, do you have a photo ID?
I don't, Your Honor.
Oh, they can take a photo, somebody take a picture of her and give it to them. Just send it. All right, we're going to come back with this. And she's in custody because she's late, correct? And you're on GPS and you're late. Why were you late?
There was a long line outside, Your Honor. to get in on the courthouse. I was
All right,
here.
so Deputy, what we'll do is we're going to release her so she can go and do her UA. All right?
Judge, will she be brought back here today? So should I just go ahead and
Oh,
wait?
no. Yes, wait. She's going to go straight over there and she's going to come straight back. Her fiance is here. I'm sure he can drive her.
Yeah, sounds good. Oh, I'm sorry, but her counsel, I should wait, right?
Yes.
For her to come back. Okay.
And if you speak to Miss Abrams, she'll tell you where you need to go. Oh, and counsel, your exhibit you wanted me to review? Thank you. All right, and this is State of Texas versus Robin Huerta Hernandez. You entered a plea to violation of condition number 4. You entered a plea of true. The court ordered a UA, and you informed the court that you would be negative. I'm sorry?
Want to do that, and I'm sorry I did it to you. And asking you to make these things, and I do want to change. I am changing. I have changed. People have places and things. I do have support now, family support, and nobody knew me. I thought it was quick about me, and I'm sorry for lying. But I do want to change, but I'm wrong, and I am.
All right. All right, is there anything else from the state or the defense?
And there it is, 3 years in prison. All that hope, the fiancé support, the NA meetings, gone in an instant because a drug test came back dirty. This
All right, you've been missing for many months. That's what your plea of true was. I was informed that you were going to be clean, that you've been doing great work, but you were not clean. The court is going to grant the motion. The court is going to find you guilty. The court will revoke, request the therapeutic community. How much time are you asking for, state? Defense, what are you asking for? All right. The court will sentence you to 3 years in the prison, give you credit for any time served, and the court will retain jurisdiction. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Right. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Good luck to you. I will tell you in this court, with regards to drug use, honesty is always the best policy. All right, good luck to you.